All right, so welcome to our second lecture, and our second topic is about the legal environment because, for a number of different reasons, but our audit report, whoops, I've got my pen on the wrong thing, because our audit report is a public document, all right? So people and members of the public use our document, they rely on it, they make decisions based on it, and as a result, like anybody that makes a good or service that is used by others, then there are some potential liabilities that come with that usage. So we're going to look at the legal environment, and then we're going to look at a separate chapter, which is audit quality and ethics. So what makes a quality audit, and what do we mean by having ethics? And I've got two articles up there. The first one from 2015, and ASIC has the power to suspend auditors doing the wrong thing. We'll talk about those particular options. And then in 2012, a PwC partner was actually banned from working on audits for, I think, 3 years. So it's 2012 until 2015 for failing to require a client, which was Centro Shopping Centres, Centro just here, from failing to identify that a client needed to classify $2.1 billion worth of its debt as current. So that debt was due in the next 12 months, but the board managed to say, oh, look, we'll stretch it out, we'll put it as a non-current asset, and the company certainly wasn't a going concern. Oh, thank you very much to the person who closed the doors. We got a lot of outside cafe noise there. So the first chapter is going to be chapter 2 about the auditor's legal environment, and we're going to talk about what sort of laws the auditor is exposed to and what we need to do about that particular exposure. So we're going to talk about a few different objectives. I'll just quickly highlight some of the most important ones. We're going to look at the elements of our dynamic and regulatory environment. Oh, that's a really big highlighter there. We're going to look at the statutory requirements. We're going to look at, what happens if we do something intentionally to defraud or deceive? Then we could be charged under the Crimes Act. We're going to look at some basic legal concepts and then figure out our liability to two different parties, to the clients and management and to third parties. Okay, so the clients and management will actually look at their legal liability under contract law. There. And then to third parties, we're going to use the common law. Remember, common law is law based in precedent, where judges make decisions and those form the laws. We're also going to look at what are my responsibilities for detecting and reporting fraud. We do have some responsibilities. And how we can manage, but in other words, really try and minimise our legal liability. All right. So the only way we would eliminate our legal liability altogether would be to stop doing audits. We certainly don't want to do that. We want to try and minimise our legal liability. I've got to keep an eye on the time because it's a really long lecture today and I want to make sure we don't miss out on anything. So what about the regulation? Audit is a highly regulated profession. So the Australian Stock Exchange has requirements for listed firms to receive audits. So they have to have audits by a registered auditor. ASIC actually goes out and they enforce the Corporations Act. All right, so ASIC's role is twofold. It's investigation, all right, and then they recommend to the CALDB, which is the Company's Auditors, Liquidators, Directors Board, about whether anybody should be charged under the Corporations Act. So ASIC plays a really big role. It monitors companies, it monitors directors, it monitors officials, as well as auditors. So they have a really wide-ranging brief. You've got the Prudential Regulatory Authority, which also has oversight. The Australian Competition and Consumer Commission, and we've got an error here, oversees the CCA. All right, which is the Competition and Consumer Act, which was the old Trade Practices Act. This is the new one. So the ACCC investigates and enforces the CCA, and then within each state, we have Fair Trading Acts. But most of the time, we're looking at things here from a federal level. So in terms of my liability, I have criminal liability if I intentionally do something wrong. I assist a client in fraud. I have my consumer law, which is based around the idea of misleading and deceptive conduct, which is the CCA, the Old Trade Practices Act. So anything that we do could be construed if we were intentionally misleading and deceptive in our audit opinion. And then we're also subject to the requirements of the Corporations Act. Add to that, I should add another little bubble in here. Let me do it. We want the bubble in orange. All right. To add another one in there, we also have contract law. All right, because the auditor does really sign a contract and creates a contract between themselves and their client. And we'll get into each of those options. Okay, so in terms of crimes, what sort of things could be a fact? The Crimes Act requires reporting of offences to the police, tax officials or customs officials if we discover criminal activity by our clients. Okay. So if we discover criminal activity by our clients, we must disclose. As an officer of the Corporations Act, we have to disclose. If we fail to disclose, then we are going to be just as guilty or complicit under the Crimes Act. Now, to date, no auditor has ever gone to prison in Australia. I don't think anybody has ever been really risky enough to decide that we're going to discover some criminal activity at a client and not report it. So auditors in Australia so far have been very good at high quality in terms of reporting. One situation in which we know that companies or that the auditor did not report was this company, Enron, where they knew that managers were not doing the right thing, and then they even sort of dug themselves in a bit of a deeper hole when government investigators came to subpoena their documents. They started shredding them, destroying evidence before they hoped the government could get at it. So certainly we want to make sure that we're always doing the right thing. So what about consumer law? And I mentioned the CCA, which you see just here. So the Consumer and Competition Act of 2010 pertains to individuals. So here, when we talk about individuals, we could be talking about individual partners. All right, and when you look at, partners of the audit firm. All right, and when you look at an actual audit report, the partner states their name. So you know exactly which partner is responsible. Now there has to be misleading and deceptive conduct, and generally what we also are looking for is intention. All right. So to be charged under this particular area, the auditor had to have known that they were being misleading and deceptive. If they didn't do it by accident, there's usually some requirement for intention. Now, Section 18 of the Consumer Law and the Consumer Competition Act says there's no notion of something called proximity. And proximity is a really critical audit concept, so much to the point that there's actually a video in your folder this week about the idea of proximity. So if you go into UTS Online this week, there's our lecture slides, there's an overview of auditor liability, sort of done in a different way. So we're following the textbook's layout here. There's a different way of thinking about liability in a YouTube clip. There is a clip from a law professor about proximity. It's about 45 minutes. That's long reading. If you're really interested, go read it or watch it. If you're not that keen, I'd give it a bit of a miss. And then there's also a short 10 to 15 minute video on liability to third parties and the idea of proximity. So it's one of these really critical concepts that I suggest students should really understand before next week's quiz. So anybody can sue the auditor theoretically under the Competition and Consumer Act. However, most of the time, charges under the Consumer and Competition Act are brought against companies of any sort, whether you make washing machines or cars or food, by the ACCC. So theoretically, you'd need to convince the ACCC to investigate and bring charges against the auditor. Theoretically, anybody can, but it's usually the ACCC. Corporations Act has lots of regulation about everybody. Directors' responsibilities, who can be a director, who shouldn't be a director, companies, setting up companies, folding companies, share registries, dividend payments, everything about companies is covered in the Corporations Act. The key things for us to think about today is auditor independence. So independence is the cornerstone of our ability to give an objective opinion. The Corporations Act now requires an independence declaration. No, I can't spell independence. Where the auditor must sign as part of their audit report a document that says, I'm the auditor, everybody on my team meets the Corporations Act independence requirements. Why do they have to sign that document? Because if ASIC inspects you on an annual basis for the Big Four and on a rotating basis for everybody else, if they inspect you and they find that you've breached the independence regulations, they've got a signed piece of paper where you said you were independent, and they go, gotcha. All right? So you said that everything was correct and independent, but if they find a breach, you're automatically going to be in trouble. Because here in this declaration, then you've not been telling the truth. So they sort of get you either way. The specific rules about appointing, resigning, removing auditors. The key one I want to talk about here is rotation requirements. So every 5 to 7 years, you must rotate the audit partner. All right. In the United States, it's rotating audit firms. We don't have enough firms to rotate that many. So we just have 5 to 7 year audit partner rotations. There's also cooling off periods. And that means that if you want to go work, you work at an audit firm and you want to go work at your client, you have a cooling off period of 2 years. You can't go to work at your client until you've been out doing something else for 2 years. Now, why is that significant? When I started as an auditor many years ago, only one person out of my class of 30 graduates or 30 trainees is still at PwC. And she just made audit partner this year in the last round, which is really exciting. But almost everybody else went to go work at one of their clients. And the reason is that you get to know the clients get to know you, you understand their work process. So you know the company, they understand how you fit in, whether you're a good fit for their style of organisation or not. So it was one of the most popular places for auditors to go as their next step in their career progression. We even had one partner who left PwC to go work as the CFO at one of his major clients. This was all before Enron. Post-Enron, we now have cooling off periods of 2 years for senior staff. I'm not sure if that would apply to graduate auditors going off to clients, but certainly for senior staff, there are cooling off periods for 2 years. The other thing that we also have to worry about is our auditing standards. So our auditing standards are legally enforceable. The Corporations Act says you must follow the auditing standards as a minimum. That is why our auditing standards have all sorts of words like the auditor must or the auditor shall. In a lot of the international versions of the standards, it says the auditor may, which sort of says, well, it's a bit optional. But here we have legally enforceable auditing standards, which has these slightly different words. We also know we have to report for our audits, all right? So just like Anything else in terms of reporting obligations, we have deadlines to report by. And then the Corporations Act also allows audit firms to be incorporated to try and limit the amount that people could sue for. We also have in New South Wales caps on how much you can sue for. So in the US, you could sue for any amount of money. Here, I think it's an amount up to 10 times the fee of the audit, depending on the size of the firm. So there are caps on liability. Now, in terms of criminal liability, I mentioned before that, the idea is to defraud or cheat, and with that comes the idea of intention, all right, because intention is one of those key things about fraud. We won't worry about the vicarious liability thing, that's okay. I'll just cross that out from our slide today. So let's look at some basic concepts. The first one is the idea of a reasonable person. So what would be reasonable of someone to expect in terms of what someone should be able to do? So here we have a reasonable degree of professional skill and care. Let me just highlight that. How do they figure that out? They get experts in a room, or they get experts appointed by the court to examine what would be a reasonable judgment for an audit manager, for an audit junior, for an audit partner. Obviously, a partner is expected to be able to do more complex judgments than a vacationer or an intern or an audit junior. But we use professional experts to determine what is reasonable. There is possibility for being liable for the acts of others. So partners are liable sometimes for items or issues that happen within their firm, but more importantly, partners are liable for the work of employees. So any manager, director, senior auditor, graduate auditor, intern that works for them, if those people make a mistake, the partner does become liable. Is there a question up the back, or are you just stretching your arm? Stretching? Okay, awesome. So it's really important, and the reason why the firms are sort of typically shaped a little bit like this, where you have your partner up the top and then you have your junior staff, is that there needs to be layers of review. All right, so you might have a couple of different layers. The junior staff will do some work here. The next people up will check that work. All right, the manager will check the senior's work, and the partner will check the manager's work, to make sure that somebody is always confirming that what the lower level staff member did was appropriate. And that is because the partner is liable. Their name goes on the audit report. We know exactly which partner it is. So they're liable for the work of employees. What's also important is that they're liable for the work of other firms. So this is especially true where you need to use audit firms in other countries. So you might not have an audit office for your firm in a country of a subsidiary where you need to do an audit. So you might need to hire somebody local. If they're not up to scratch and they make a mistake, you as the partner in the originating country, that could be Australia, it could be the US, are going to be liable for what happens in those firms. This is quite a big risk, to the point where a friend of mine who now she's a VP at News Corp, but she used to work for Ernst & Young. And Ernst & Young didn't trust the local audit firms for one of their clients in, I think, the Bahamas, that they sent her and her team to do the audit in the Bahamas for 2 weeks. I thought, that has got to be the world's luckiest job. I've requested many times to go check that money in Swiss bank accounts is really there. I never got approval to do that. But you need to be careful when you hire audit firms in other countries. It could even be the same firm. So we might have a big company here that has branches in New Zealand. If we're at PwC, we might rely on PwC in New Zealand. We're still responsible for anything that they do. And we might also be responsible for specialists. So sometimes we might hire a mining specialist or a science specialist. We're also responsible for any judgments they may make that we rely on. All right? So that partner up here, the buck stops with them. And they are the people who are going to lose out if something goes wrong further down the chain. So we're going to talk a little bit later about why quality control is really important to do that. Now, one other key thing is there's a lack of privileged communication. So we normally see privileged communication between two types of parties. Doctor-patient confidentiality, where you can't, even after someone's died, the doctor doesn't have to disclose anything about that person's medical history. And the other one is what we normally see as attorney-client privilege. All right. So doctor-patient and attorney-client privilege means that even under impetus from a court of law, a lawyer doesn't have to say what their client told them. All right, that's privileged. Unfortunately for auditors, our communication with the client or anybody else is not privileged. We do sign a confidentiality agreement that means we're not going to tell anybody, but if there is a lawsuit, then somebody can subpoena our work or our documentation to use as evidence of communication or proof of transactions or something else that's going on. So this sometimes means that companies are a little bit, or audit firms are wary of what they put in documentation. They might not want to put something that's very controversial or that might be verbal only evidence, just in case it ever does get subpoenaed by somebody else. All right, now, in terms of our liability to clients, we could fail to perform our auditing functions with due care. Now, I'm going to go back a little second. I'm going to draw something and we'll see how we go with my drawing because, I'm not really an artist, but let's try this out. All right. Okay, so do we know what that is? Snail. All right. And also let's see if anybody knows what I'm going to draw next. And the GB stands for ginger beer. This is the extent of my artistic talent. I'm sorry if you came to see more. But the snail in the ginger beer bottle was a pivotal case about owing a duty of care to somebody. It said that, well, if you make a product that people are going to consume, you owe a duty of care to make a product that they can actually drink, not one that contains snails. I think it was a slug, but we use the analogy snail. I think snail and slug are interchangeable. But this is the key foundation for the idea of owing a duty of care. So as the auditor, we have a responsibility to perform our functions with due care. All right? We have to have the right skills, we have to apply ourselves fully, we don't take any shortcuts. So I could be liable to a client if I fail to act with the proper amount of care. Right? It's the same as if you're a doctor and you go to amputate someone's leg and you amputate the wrong one. You failed in your duty of care. So the duty of care concept comes from common law and originates from the snail in the ginger beer bottle, Donahue and Stevenson. The second area of law, so that duty of care actually links to the tort of negligence. So the tort of negligence comes from the common law. It's all based in case law. So this is sort of the first area where we have this duty of care. We also have contract law. So an audit is like any other business transaction. There is a contract between the audit firm or the audit partner and the board of directors to provide the audit by a certain date following particular standards. We actually have an auditing standard, and that standard ASA 210 sets out, doesn't look like a zero. ASA 210 and ISA 210 actually set out the standard contract for every single audit. It's simply replace client name here, replace dates there. Now, of course, our liability under contract law is only for the terms of the contract, so they can't sue us for anything else. But duty of care in the common law means that we can get sued for anything that might not be covered under the contract. All right. So the tort of negligence says, I must act with duty of care. If I don't act with due care, then I am going to be negligent in my duties and liable potentially for any losses that arise from that negligence. So if you cut off the person's wrong leg, so they've got something and needs an amputation, then you cut off the other leg instead, then potentially you're liable for, if that person is a delivery driver or an athlete or does something that requires them to walk around, then you could be liable for any losses that stem from that. How are we doing on time? Okay. So in terms of my liability to clients, and this is specifically from an audit perspective, we go to London and General Bank. Now, when it comes to cases, I want you to focus on knowing for next week's quiz the cases that I talk about in the lecture slides. I'm not going to talk about every single case that's in the book. You can have a quick read over them, but the cases that are in the slides are the cases I want you to make sure that you know, and then I'm going to highlight some of those specific cases. So London and General Bank was one of the first cases that said the auditor owes the shareholders a duty of care. And the key was that we owe shareholders a duty of care. Okay. So we have a direct contract with the directors, the board of directors and management. I don't have a contract with every shareholder. Right? That'd be impossible to sign an audit contract and get every shareholder to sign it. But I do owe them a duty of care because they are the eventual users or consumers of my audit report. Kingston Cotton Mill will come up twice. First it says, we must use all of our skill, care and caution that a reasonably competent, careful and cautious auditor would use. Okay? And this raises a concept of something called professional skepticism. All right? This means that we're always wary. Okay? We're not conspiracy theorists that, every single piece of data is being tracked and used to do something nefarious, but we're saying for pieces of evidence, does this evidence look genuine? Does this evidence fit in with the story of what I know about this client? And it's quite often, and I use professional skepticism all the time. Students come to me and they say, especially when they fail, it's never nice when students fail, they come to me and they say, Amanda, I tried really hard for the final exam. And I say, well, okay, I've logged onto UTS Online and I can check that you haven't been on UTS Online during the exam period. I can see that you didn't click on the video that has all the exam hints in it. I can see that you didn't sign up to the study program. So for exams, we actually run a 12-day step-by-step study program for auditing to help you summarise everything that you've learnt in the course. So they haven't signed up to the one email a day thing that we give them. They haven't come to ask a question at consultation at all. So when a student comes to me and says, Amanda, I really tried really, really hard, my professional skepticism hat says, well, I've got no evidence of you doing any of that. If you'd come to me every week with questions and then you'd bombed out in the final exam, I'd go, well, that seems really weird because I've been keeping an eye on that student and they seem to have a good handle on things. Then if you come to me with oh my God, something happened and we had a student the day before the exam, their pet had passed away. And the student I knew quite well, but apparently the student was despondent, depressed, had been to see a psychologist, and we'd had a letter from the psychologist telling us about how traumatised they were from their pet's death. And so there, even though I'm a little bit sceptical, and I would be really upset if my dog died, about how much the impact was on the final exam, I knew the student had been working hard, they'd come to see me a lot, and I had evidence to prove that they were emotionally traumatised, so I went, well, okay, let's give that student another chance. All right? So don't use the dead pet excuse. I want to see death certificates from vets. Seriously. And I used to say to students, if you get hit by a bus on the way to the exam, I want to see the hospital admission form. But then I realised I might be encouraging students who didn't feel confident to jump in front of a bus. So I don't say that anymore. But we have to use all of our reasonably competent skill and care and caution. And then one other key case that I want you to have a read of is Pacific Acceptance. It's a case from 1970. Pacific Acceptance really was the case that helped establish most modern auditing standards. So if you're really curious, go and read the legal judgment. And a lot of the things it says about Pacific Acceptance, like you have to have a written report for the audit. You have to have objectives for the audit. You have to audit the whole year. That sort of makes sense to me, but until 1970, that wasn't enshrined anywhere. You have to collect evidence. Legally, up to 1970, there was no requirement to collect evidence to generate your audit opinion and your audit report. You could have just, I guess, gone with a gut feeling, which probably wouldn't have been really great. Pacific Acceptance also said you have to consider the possibility of fraud and look for red flag indicators of fraud, which we're going to talk about again in relation to Kingston Cotton Mill, but in a slightly different context. We also, under WA Chip and Pulp, have a responsibility to inform management if we find something is wrong, right? Again, this is part of our reporting duties. So if we discover that the client is doing something illegal, we must tell them, or we must tell them if there's any deficiencies in their internal processes. So if we discover a little loophole that allows employees to steal money or charge overtime when they really didn't work it, then we have a responsibility to actually tell management about that. One of the reasons that we also do that is that it makes our clients feel like we give them value. Because most of the time, clients grumble. All right, is anyone here an auditor? A few people, right? And they're never very happy. Oh, the auditors are here. Oh my God. Okay, let's stick them in an office and pretend not to provide them with the things that they need or drag our feet. All right, clients they have two approaches to dealing with the auditor. They are so nice to you and they help you with everything so that you'll get out of their hair quicker, or they're really, really nasty because they think, I've got too much of my own work to do. And I'm sure people who here might work in accounting jobs might dread the day the auditor comes around. Oh, the auditor's coming. They're going to ask for documents. They're going to want to find out how I do my work. They're going to need to confirm information with me. How am I supposed to do my job and do all this audit communication at the same time? So one way that we try and convince our clients that we add value is that we tell them, oh, look, we found this issue. We found this problem. We found these things. And those are things that management can improve upon so that their own financial performance and loopholes are minimised. Now, there is the possibility, if the auditor was negligent, the auditor did something wrong, that somebody else could contribute or, as I like to say, share the negligence, right? Because lawsuits are always about who is to blame and who is going to pay the money for the financial loss that I've suffered, right? Somebody has got to be to blame. That's the whole idea. That seems to be where our entire legal system is headed. It's about blaming someone for something. So the idea of contributory negligence is, was it someone else's fault as well as mine? This is something that contributory negligence comes up a lot with my 3.5-year-old. Why is that muffin on the floor? Oh, I was eating it and then the dog knocked it down on the ground. Or, how did this bowl get broken? Oh, it was sort of me, but it was also sort of the dog. Our dog gets blamed for a lot of things, unfortunately. She can't fight back. But contributory negligence is this idea about sharing negligence with someone else. And that could be in the instance if perhaps we relied on some information that somebody told us that might have been false. Somebody might have given us copies of bank statements that look so genuine, they were professionally forged, and we didn't notice the difference. In the AWA v. Daniels case here, the auditor was in trouble because management had made some really bad decisions, but the auditor was the contributory party because the auditor forgot to check that what management was saying verbally was actually the truth. And if they'd gone to the actual documents at AWA, they would have discovered that management were lying through their teeth. So sometimes the auditor can make the mistake and it can be partly contributed to management fraud or deception. Sometimes management can make the mistake, and as in the instance of AWA, sometimes it's partly the auditor's fault for not saying anything or not asking the right questions. Why are we interested in contributory negligence? Because when it comes to lawsuits and payouts, we want to be able to share the pain of paying out somebody with someone else. We don't want it to be all our fault. We want to say, look, 90% is our fault, 10% can be paid off by somebody else. So what about liabilities to third parties? Because we know that we have certain relationships. We have the audit firm in a relationship with the board of directors, and then we have the board of directors representing our shareholders. All right, so these guys over here have a contractual relationship with each other. All right, there is liability. The auditor is liable to the board through contract law. The board is liable to the auditor through contract law. But how would the shareholder do something about trying to sue the auditor? And they do it through something called being a third party. All right, so an auditor is the shareholder is technically a third party. So is also a lender, a customer, a supplier. Anybody else who uses the financial statements, relies on the financial statements that the auditor produces, but doesn't have a direct relationship, is going to be a third party. And the question becomes, which of these third parties do I owe a duty of care to? Should I owe a duty of care to all of them, some of them, or none of them? And when we look at the case precedent, or all of the case precedents that we're going to examine today, that's the big question. Which of these parties do I owe a duty of care to? And it's going to come down to a concept that I mentioned a little bit earlier and that I'm going to get into in a lot more detail, but it comes down to a concept that we're going to call proximity. All right? So the legal cases say there must be a reasonable degree of proximity. Now, if I think about proximity between me and this gentleman right in front of me, quite close. All right? But the proximity between myself and the guys up the back of the lecture theatre is quite a long distance. So if I was the board of directors, proximity is close. Proximity becomes further away to the shareholder and even further away to these parties as established by courts of law. And we're going to go into the reasons why these guys have a reasonable amount of proximity to the auditor, but why lenders, customers and suppliers don't really have much proximity. So I'm going to go first to Donoghue and Stevenson. Donoghue and Stevenson raised the idea about a duty of care, owing a liability to somebody else. All right, that was the snail in the ginger beer bottle. The Candler and Crane case said that there needs to be a contractual relationship that establishes a fiduciary duty. All right? So if there's not a contractual relationship, then we're not going to have proximity and we're not liable to that third party. However, we move to a number of different cases which raise the idea of foreseeability. Who is likely to have been reasonably foreseeable to use the financial statements? As the auditor, I'm pretty smart. Who could I predict would rely on the financial statements? Would use or rely on the financial statements? That list could get pretty big. If you knew the company was going for a bank loan, it could be any bank out there. If you knew that they were going for different credit terms with suppliers, it could be any supplier out there. So have a quick read this week of these cases and just have an overview of them, because I'm going to get to two really important cases in just a minute. So in the idea of proximity, there is the case of Caparo. Now, Caparo is a UK precedent, all right? It's not the current precedent, but they said there has to be three things. Foreseeability, you have to foresee that someone could rely on it. It had to be reasonable to expect that third party to rely on it. And there has to be proximity. There has to be this closeness. How do we define what that closeness could be? Comes from this case here. So this is the current Australian precedent. And this is the one, let me do this here. This is the one that's really important. Very important. Whoops, let me undo that. So important that I'm putting these big purple stars here to say really important case. All right. So Asanda, and there was a case previously called Columbia Coffee and Tea, which said that realistically, if you named a company in your audit documentation, the name of a supplier, name of a lender, name of a bank, then that person would have proximity. And that was really dangerous because that really exposed us to liability from anybody who was involved in the audit. Any client, any supplier, any customer, it could get really, really tricky. But in 1997, so Columbia Coffee and Tea was, I think, from memory, 1992. I'd have to double check that. But they said that in the Asanda case, and this is not on the slide, but I'm going to add it here, is that the the auditor must encourage, entice, or induce reliance by a third party for there to be proximity. For there to be proximity. All right. So the auditor must encourage, entice, or induce. And they also said within that the report was prepared on the basis that it would be communicated to a third party. Who's ever read an annual report and the auditor's report? All right. People who've already been to tutes will have seen one already. People who haven't been to a tute, you get to do that tonight. That audit report says, usually, in the text of it, dear shareholders, or to the members or to the shareholders of XYZ Proprietary Limited. So what the auditor is doing is we're saying we're preparing this report specifically for this third party and this third party alone. Okay? We have to know that the report is likely to be relied upon them. Well, we expect that with shareholders. They make their decisions based on it, and they could suffer a loss. But when we say dear shareholders, we are encouraging, enticing, or inducing. All right? The annual report and the audit report does not say dear general third party. It doesn't say dear lender, doesn't say dear supplier or dear creditor. It says dear shareholder. And the reason it does that is to limit proximity. Okay, so that is there to limit proximity to just current shareholders. Not future shareholders, just current shareholders. Now, if you're a third party, you can request something called a privity letter. So let's go into those. Oh, hang on. Oh, I'll go into privity letters, I think, on a future slide. Now, there's a 5-step test. This is not in your textbooks, but this is the best way, in the way that I explain in my YouTube videos, about whether we owe somebody a duty of care and whether we're going to win or lose in a lawsuit. Step number 1, do we owe a duty of care? Is it a contract law case or is it a tort of law case where we have to figure out using Asanda? All right, so this is where really Asanda comes in. And this is where all the sticky judgment decisions are. Do we owe a random third party a duty of care? Number 2, did I breach my duty of care? Did I go out on a Thursday night and get absolutely stinking drunk and then on Friday morning come in still hungover attempting to audit and muck it up really badly and be negligent is one potential option. So identifying a breach is pretty easy. They'll get an expert in and they'll say, was this reasonable, yes or no? Third thing, was there a financial loss? We do not compensate for emotional damage. So if you're feeling really emotionally distressed because you invested in a company and then things went bad and then you lost all your life savings, there's no compensation for that. Investing in the share market is a risky proposition within itself. And by investing, you accept part of that risk. So we don't remunerate, we don't compensate for emotional damage. Now, it's very different if a doctor chops off the wrong leg, all right, or the wrong arm, and that's the arm that you use to make a living, or it's, you're a hand model, or your hand double in the movies or something, all right? You could be compensated for emotional distress. But when it comes to the tort of negligence for legal cases in relation to auditors, money loss only, which is usually the value of your shares. Number 4, did anybody contribute to the negligence besides the auditor? And then our key one at the end, was the loss caused by the auditor's breach? Did what the auditor do up here result in the eventual financial loss? So there has to be cause and effect, all right? If we made a mistake on something very small that would have had no impact on the eventual financial report, there's no cause and effect. So that's the key. But the big sticky area is always this one. Do we owe that party of duty of care? And then was there, 2, 3, and 4 are pretty easy to determine. And then was there cause and effect? Now, I mentioned before privity letters. And a privity letter is a letter that a third party will send to the auditor to formally acknowledge their reliance on the audit report. So what they do is they say, "Dear auditor, we know that you audited the financial statements for XYZ Limited for shareholders. However, we would like to use that for our decision-making purposes. Can you please write us a letter guaranteeing us that the information is suitable for what we want to do? If you're an auditor, would you ever want to sign one of these letters?" No. All right. To the point where when I was back at PwC and I was a student and I learnt about privity letters, I thought, I wonder what we do when someone sends us a letter. What do we send back to them? Do we just say get stuffed? Do we write a nice long letter? And I went into PwC's pro forma database, which has all the different sorts of letters, contracts, etc., standardised forms. There was no letter to respond to one of these privity requests. So I went to the legal and methodology team who create all these templates. And I said, why isn't there a letter to respond to a privity letter request? Because at the time, AGS 1014 said that I should write back to anybody who sends us one and say, thanks for your letter, but sorry, we're not going to grant you proximity, essentially. And when I spoke to the lawyers, they actually said to me, we don't even want to acknowledge that a privity letter request came in. When we get them, we take those letter requests and we throw them in the bin. Pretend like they didn't ever even exist. Because to create proximity, the auditor has to write back and say, dear XYZ Limited, dear third-party user, the audit report of XYZ Limited was prepared for shareholders, but we are willing to approve its use by you. Nobody ever wants to say that. So they said to even stop people from writing back saying thanks but no thanks, we're just not even going to create a template. All right? AGS 1014 has actually been withdrawn from circulation now. So now there is currently no guidance to auditors on what to do on these requests, but my understanding of practice at most firms is that you take the request and you throw it in the bin. All right? Sometimes, if somebody calls back, you might say, well, if you'd like an audit report, you're happy to pay for us to audit that company and we will give you a report. If you pay us, we're going to have a contract and then we will have proximity. All right? Then you will have your ability to sue. And that's where the Asander case came from, because Asander was a third-party lender who was relying on a general purpose audit report for a company, not a report specifically for them. So I've never seen a firm in the last 20 years ever issue a privity letter. Ever. Ever, 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 never. All right. So if you ever get one, you just toss it away. I said to them, look, why don't we even want to respond? And they said, well, the court at the moment will say that you have to sign a letter saying, we're assigning proximity to you, and we're approving your privity letter request. But the court might change its mind in the future. The court might say, even acknowledging that they were going to use it creates reasonableness and foreseeability, and therefore could it be proximity? So they don't even want to take that risk, which is why we don't actually see responses to privity letters. Disclaimers. when you go to a theme park and they say, you know, by buying this ticket, you cannot sue us for any injuries you get on any attraction or any ride, you cannot disclaim your liability to clients. So you can't somewhere in your engagement letter sneak in a little paragraph that says, by signing, you agree not to ever sue us. You can't remove that liability at all. All right, the purpose of the audit report is, under the Caparo case, which is the case that came out of the UK, it's information to shareholders, all right, and to all shareholders, not intended for potential investors. All right. If you have companies that are engaged in takeovers, they will usually engage in something called due diligence, which is sort of a bit like a mini audit, and they will pay to have that done themselves. So that if something does go wrong, they have proximity to an auditor who has done this investigative work for them. All right, who's responsible for detecting fraud and error? We have reasonable care responsibilities. If the fraud is extremely complicated and it required 10 years and 20 mathematicians to figure out what was going on in the data, then that would not be reasonable expectations of an auditor. But if it was reasonable for the auditor to detect, then we have responsibility to detect it. Kingston Cotton Mill is the most famous case in relation to fraud, and it says, the auditor is a watchdog, not a bloodhound. That means my job is to keep an eye out for anything that looks suspicious, and if I see something that looks suspicious, I call those items, and most of the literature calls those items, red flag items. All right, that's meant to be a flag. It doesn't really look much like a flag. My artistic flair is pretty limited. But let's assume flag, just in case anybody's looking at it going, what the hell is this? So if you see something out of ASA 240 that is a potential for fraud, as the watchdog, you must investigate. You must check it out. But what we are not doing is we are not searching for fraud. All right, the audit is not a fraud investigation. And the reason being, if I had to do an audit like a fraud investigation, an audit would take me 2 or 3 or 4 years, not 6 to 8 weeks. So fraud investigations and forensic investigations are a totally different method of investigating organisations. So the Kingston Cotton Mill case, which still stands today, which was reinforced within Pacific Acceptance and is now reinforced within ASA 240, says, I keep an eye out for the flags, the red flags. The back of ASA 240 actually lists hundreds of them, hundreds of things you should be aware of as the auditor. And if one of those pops up, jump in and investigate. Okay? All right. So I've lost all my edits on the slide. That's annoying. So clients with integrity, we want to make sure we pick the right people to hire, train them well, supervise them, follow our standards because they are a force of law, independent so we can be objective and people can rely on our opinion. Right? This is sort of a bit like Kanye West. When Kanye West burst up onto the stage at the VMAs and he's like, Taylor Swift, you won the thing, but I think Beyonce's video is the best video of the year. He's not really independent. He's not an independent judge. I don't know if I trust his opinion. I'm not sure if I trust Kanye's opinion on many things. And then I need to understand the client's business. All right. I also want to perform quality audits. I want to follow the auditing standards and do the best of my ability. All right. So work to the highest standard. I'm going to have to apologise to my mum later for hanging up on her FaceTime. She's going to be really upset. You don't want to be on the phone with me for that call. All right, we need to document our work properly. The reason documentation is really critical is because I can't remember what I had for lunch last week, let alone what decision I made on an audit 5 years ago. All right, so if you don't document how you made your choices, why you made your choices and the evidence you used, then when the court comes to you and says, Will, how did you make this decision? And you go, I flipped a coin. I don't know. What does the work paper say? It's blank, or it just says, the decision without any justification, then you're going to be in big trouble. So documentation is really important. Having an engagement letter, which is the contract, under ASA 210. Oh, that's a really skinny pen. Let me change that. ASA 210. And a representation letter, which is ASA 580, are really critical. Now, the management representation letter, this one here, is a letter that management sign where they say everything I've told you is the truth, the whole truth, and nothing but the truth. I haven't lied to you, I haven't forgotten or omitted any information, I've given you all the information. Audit firms, like medical practitioners and lawyers, also have insurance. So that if you do stuff up and you don't have the $400 million to pay out, then the insurance company will pay. But just like any insurance policy, once you start claiming, the premiums go up. All right, so you can have insurance. We also have in Australia a cap on how much you could sue the auditor for. So I think it's 10 times the audit fee. So in the US, you could sue the auditor for billions of dollars. Here, there's maximum caps. And then anytime you're unsure of something, obviously seek the advice of a lawyer. Thank you. All right, thank you to that person. Come down and see me at the end. I have a prize for you. Seriously, I do. So a couple of things. We want to make sure that we've remove the conflict of interest that comes from agency. We want to have accountability and transparency, and that comes out in ASA 701 and the new key audit matters. And this semester is really exciting to do auditing. You know why? This is going to be the first full year that we are going to have firms moving and producing audit reports with key audit matters. We already have 3. We could have heaps more by the end of the year. It's going to be a really exciting time to be looking at annual reports. So audit quality, you guys don't look so enthused as I do. Audit quality has 2 components. Number 1, the ability to detect an error, and that's based on our skill. All right, competence is really skill at doing it. Number 2, as well as being able to detect an error, you have to be ethical enough to say something about it. And the place that we know companies were not ethical enough to say something about it was Enron, where they certainly knew things were going on and they found errors and refused to report them because management promised them bigger consulting fees in exchange for keeping quiet. All right, so quality depends on 2 things, being able to detect the error and having enough ethics and integrity to report it. ASX also has good corporate governance principles. Those are pretty basic. You can read about those. Now, the expectations gap. The diagram's a little bit small here, but this is like those memes, right? Society expects an auditor to do one thing. An auditor really is supposed to do this, and this is what actually happens, okay? Now, society has no idea really what auditors do. My mum used to think that auditors gave an unqualified opinion and that meant that managers were doing a good job. Realistically, managers could be doing a shithouse job, but as long as the company was telling the truth about how shitty their financials were, you could still have an unqualified audit opinion, right? So society has lots of expectations, and there's a gap, a reasonableness gap between our legal duties and what society expects. Society expects lots of protection from auditors, and we just don't have the ability to give it. The other gap here is the performance gap, and that comes from 2 particular areas. The left one here is deficient performance. That's us being negligent. All right, so if I'm negligent, I'm not doing what I'm supposed to do. The other option here says deficient standards. Now that happens because technology and the world and business community moves faster than standard setters do. Is there a standard, an auditing standard, related to how we handle bitcoins? No. Is there an auditing standard about how we should handle the security and authenticity of blockchain transactions? Because blockchain is meant to be this very secure method of transmitting information. No. Up until recently, only in the last 5 years, do we now have a AASB on complex financial instruments. We had warrants and all sorts of complex financial instruments for probably 15 years before the AASB and the International Accounting Standards Board came to a consensus on a standard. So standards lag behind public practice because people are always innovating. That's going to mean there's always going to be some deficiency in legal standards. Now, firms can choose to do more. They could do more than the basic standards, but that basic level is always playing a bit of catch-up because the world is always changing. So what causes the gap? Auditing in itself is a complex, judgmental, subjective process. Hindsight, people always go, of course, why didn't the auditors pick this up 5 years after something happened? The people who complain are often journalists, all right, who want to sell newspapers. They are shareholders who have lost their money, and obviously they have some bias. So journalists want clickbait, right? Do we know what clickbait is? Some article that's such a tantalising headline that you have to click on it to read it. In the old days, they wanted to sell newspapers. They don't sell many newspapers anymore. But what they want is clicks and views and shares on Facebook and social media. All right? That's what journalists are looking for. So if something goes wrong, the first question is always, why didn't the auditor tell us something? What's going on here? Shareholders obviously are upset because they've lost their life savings. That often comes because we have large levels of unsophisticated investors within our markets. All right. So most people who grew up here, our parents will have some form of shares through ownership in IAG, which is the old NRMA, through floats of Telstra, through floats of Woolworths, and lots of companies where people, teachers, doctors, nurses, plumbers, electricians, McDonald's workers own shares in big companies. But they don't really understand what that process is about. They don't understand the risks. You can't give them the annual report and they'll look at it and go, yeah, I know what note 15 about segment disclosures is all about. So there's a big misunderstanding about what the auditor does. We talked about changes in social expectations. Auditors obviously only want to do the minimum. So there is always going to be this gap and it's going to be impossible to close. It has taken me probably close to 15 years to fully educate my parents, my mum has 2 university degrees, about financial accounting. And they've been very reluctant. My mum really doesn't want to learn about derivatives and she really doesn't want to learn about segment reporting, but I've been forcing her to learn over all these years so that she can read an annual report without calling me and asking me, what does this mean? What does this number mean? Is this good? Is this bad? What's this ratio? But I can't force that on every single shareholder. Yeah? Has anybody seen the movie Money Monster with Julia Roberts and George Clooney? Yeah? There's a guy who invested a whole lot of money based on George Clooney, who plays this stock market spruiker, his advice on TV. And then he lost it all and he went absolutely ballistic and took a whole lot of people hostage. If you haven't seen the movie, if it's on Netflix or iTunes, rent it, because that'll show you the gap between what people know about investing and how big investment firms work and what actually is going on. So it's a really great movie. If I could set you homework to watch a video, then that's it. Don't study this week, just watch a movie. All right. So we talked about the lack of understanding between users and everybody else. All right. What does it mean to be competent? Competent means you come to uni and you do the CA or CPA to have the right technical knowledge and that your firm, whoops, wrong colour there, that your audit firm implements quality control. So this is the individual and once you become a CA, the learning doesn't stop. There's always constant conferences and updates. All right, so being competent means able to interpret complex evidence, like the sort of stuff that you do in FSA and will get more and more complex in auditing. And then you've also got the professional bodies which say, what does it mean to be competent? So CPA and CAANZ And I have to say C-A-A-N-Z because they don't like us saying cans. Sounds a bit ochre, apparently. They set specific requirements on what it means to be competent, what hurdles you have to pass through, what exams you have to do to be one of their competent members. So in terms of quality control, there's actually an auditing standard. So therefore, quality control is legally enforceable. That means there needs to be leadership. All right? You can't just have audits being done by a bunch of people not communicating with someone in charge. They've got to be ethical requirements, including independence, and that comes out of APES 110 that we're going to talk about briefly. It means selecting good clients. Whoops, wrong colour there. Having teams that have the right knowledge and skills, the right mix. Doing the audit appropriately. And then monitoring our audit process to make sure that when we say we're doing things, everybody is doing the things that we say that we're supposed to do. Right? This would be like having subjects with no exams. Students would be like, that's fantastic, but then we've got no monitoring that you've learnt the things you need to learn. What are our ethics? Our set of moral principles or values, all right? But it's common for them to differ, okay? And I'll tell you a really great example. Somebody I know was auditing a firm that did a lot of offshore work in Indonesia, and they were trying to consolidate a line for bribery expense. And it's quite common in Southeast Asia to get anything done in a business situation to give a government official or a union official or somebody a bribe to expedite a process or to get something approved. All right? And that's happened. A friend of mine, an Aussie who's an expat, he lives in Vietnam, and he says all the time he gets stopped by police officers for something that they didn't do. And the police officer says, I'll take you down to the police station and I'll charge you unless you pay me X dollars to make it go away. All right? Does that sound common? No? Some people are saying no. Some people are saying yes. There's been a whole lot of articles, and is anybody here from the Philippines? Any Filipino students? One, right? And the big current president, his push is tough on crime and tough on corruption and graft to the point where they're executing drug dealers in the streets. All right? And in the old days, in a lot of companies, to get a lot of things done in Southeast Asia and different parts of the world, you have to pay a bribe, and that's part of the general way of doing business. There once was a company in Canada where a manager for a mine construction site got paid more than the CEO. And I thought, this is really weird. Why is that? And the only way they could legally process bribe money was that they would pay this construction manager some ginormous multi-million-dollar salary, they would pay tax on that, and then he would pay the bribes to the individual people. And it was only because we were looking through salaries and we sorted salaries from biggest to smallest, and I thought I would see the CEO's salary as the highest. And it wasn't. It was this guy whose job it was to pay the bribes. So in some cultures, some things might be completely acceptable. And I have had clients try and consolidate like the bribery expense line into the Australian accounts. And I'm like, where the hell do we put that? It doesn't go anywhere within IFRS. But that's considered quite normal. So to try and minimise differences in ethics, ethical values are incorporated into laws. And for us, our ethical values fall into APES 110. And APES 110 is enforceable under the Corps Act. So under the Corporations Act, you must follow the ethical rules and guidelines under ASA 220. So Corps Act says you must follow ASA 220, and ASA 220 says you must follow APES 110. So these are all legally enforceable ethics, which means that when it comes to reasons of why people act unethically, they might have different standards or they might be selfish, but regardless, ethics is ethics. So in our ethical dilemmas, we face all sorts of things. Do I report something? Is something important enough to report to the authorities? Is this issue big enough that I should add it into an emphasis of matter? All right, all the time, but working with a team helps us make sure that we stay on track. Now, why do people do or engage in unethical behaviour? The most common one, everyone else is doing it. I had never even considered buying really expensive fruit and veggies at Coles and putting them down as potatoes when you put them on the weigh scale at the self-serve checkout. Just never even, came to my attention. But for students, often they say, oh, look, we're on a budget. So if I want something really nice and expensive, I might buy one and then I'll put it through as potatoes. And they'll say, look, everybody's doing it. So, and the company's a big multi-million-dollar company, they can afford it. There's also the idea that sometimes, well, if it's legal, it must be ethical. That's not really the case. Some things are legal which are really not appropriate. It's legal to have freedom of speech, but we really don't want to be saying nasty things about other people. And if it's not likely that we'll be discovered or there's very little consequence, people will do it. Right? So most people will speed a little bit because they don't think they're going to get caught if they speed just a little bit. But they think, oh, speeding a lot, like going 90 in a 60, that's attracting attention. Speeding 65 in a 60 zone, probably no one will notice. Right? Same as if I said you're going to do the exam, but there are going to be no exam supervisors. No one in the room whatsoever. So we're going to lock you in there and go away for 2 hours and then come back. Then you're probably going to talk to your neighbour because you think the likelihood of being discovered is pretty slim. So how do we resolve ethical dilemmas? Get the facts, identify the ethical issues, look at the alternatives, toss up all the outcomes, and decide on the appropriate action. If you get really stuck on an ethical dilemma, CA and CPA actually run an ethical dilemma hotline that you can call if you run into trouble. So if anybody wants the number of the ethical dilemma hotline, then let me know and I will give you the number. So within the professions, we are a profession because we hold ourselves to a higher standard of conduct than the average person. So that means we need to have our own ethical code of conduct. And our ethical code of conduct, as I mentioned, comes from APES 110. I want you to download APES 110 this week, have it on your device ready for the quiz next week. Wink, wink, hint, hint. All right. And there are 5 basic ethical principles. Have integrity. Be honest. Be a good person. Be objective. And that comes into our independence. All right. Have the right skills, competence, and act with reasonable care. Confidentiality. This goes without saying. You see information about your clients way before anybody else in the public sees it. You don't tell your parents and give them a stock tip. All right? Or you don't blab about things that you might have heard going on, and then act in a way that's professional. So that means general behaviour as well as business behaviour. So that probably means not hanging out in strip joints with the CEO after hours. All right? Which I'm not sure many accountants would do anyway. All right, so APES 110 has general statements on ethical codes of conduct, but then over here, no, that's the same thing as before. I've duplicated a slide. Where is it? Here, all right, so this is APES 110. In section 290, it talks about the threats to independence. And these are the real threats to the auditor being able to be objective and do our job. These are the key things for the auditor. All right. So, self-interest. Shouldn't audit a company I own shares in because I might use that information to my own advantage. Self-review. This is like asking you to mark your own exam. Of course, you're going to give yourself 100%. So we don't ask auditors to check their own work. Advocacy. I cannot be an advocate for the client because as the auditor, I am the shareholder's advocate. Familiarity. This happens when we know somebody at the audit client. So my husband and I both started at PwC. He ended up at QBE Insurance. So, if I discovered that he'd embezzled $2 billion from the firm, because we are in a relationship, I probably wouldn't have said anything at the beginning. I might have said, look, you must have a good reason for stealing $2 billion. I'm going to talk to him. I'm going to say, look, you've got a week to give the money back. If you don't give the money back, well, then we should quietly quit our jobs, transfer the money to a Swiss bank account, and then disappear. All right? If it's a friend, somebody that you've known for 10 or 20 years, you might say, look, what is going on? Oh, I've got this gambling addiction problem. I promise I'm going to pay the money back. You give them a week to pay the money back, and in that time, they've disappeared off to a non-extradition country with all of the shareholders' money. So familiarity is something to be careful of, and this is why we have audit firm rotation. All right. And intimidation. So certainly there are lots of instances where the client says, if you don't give us the opinion we want, we will do X. Now, if you've done nothing wrong, there's nothing to worry about. But if you've helped them hide a crime or cover up a fraud, then you're caught in a really tough spot. Quite often clients will say, if you don't give me the opinion I want, I'm not going to hire you next year. And that is when you say, good, fine, I don't want you as a client, we'll let you go, let somebody else deal with this problem issue of an organisation. So there are safeguards to minimise the threats. The code, or APS 110, has specific requirements, like you can't do the accounting and the auditing. And then it's also about creating a culture of ethics and morality and doing the right thing as well. All right, so the bit I want you to look at is this bit here. All right, but there are also sections on gifts. You can receive a gift from a client for a nominal value, but if a client tries to give you a Maserati or a Tesla or an Aston Martin, you should say no. All right, this is not like Oprah where you get a car and you get a car and you get a car. Okay. All right, independence we've talked about. APS 110. Okay, 2 forms of independence. In your own mind, you must see yourself as independent. And then in appearance. So this is the no hanging out with CEOs of companies that you audit, all right, socially. No going out to, fancy charity balls together and them paying for your ticket. Even though you may be independent, the fact that a client paid for your ticket at something could be seen as not being independent in appearance. Threats to independence I already talked about in that table, the table that I had before that had the 5 threats, so that's the same thing. And so how do we try and maintain the integrity of the audit process? Committees with independent directors. All right, rotation every 5 to 7 years, having our work papers all filled out. And then if things go really wrong, the best thing you can do, resign and let ASIC sort out the mess. All right, thank you very much, everybody. I'm sorry I went a little bit over this week. Please apologise to Kate for your tardiness. If anybody needs a subject outline, I still have some outlines down the front here, so please come and take one. But thank you very much, everybody.